monthly update, and we're looking at electricity retail regulation. And we're going to be running monthly updates primarily for the energy sector. We're going to be running updates for energy retailers. This is a presentation by Law Quarter. Law Quarter is a law firm, and our clients include energy retailers, embedded network operators, energy storage companies, and renewable energy companies. So today we're going to be looking at some of the specific changes that have recently occurred that will be important for energy retailers. We're also going to look at some of the general themes of July and August, including new energy sellers and the discussion about pricing regulation. So firstly, some specific changes. AEMC has made available its terms of reference, and it's looking at development design options for a clean energy target. According to the AEMC, it will examine the ability of different schemes to achieve energy and emission reduction policy objectives in the face of changing and uncertain future consumer demand, input prices, and technology costs. Tasmania introduced a energy rebate scheme of $15 a megawatt hour, and that's going to be available to eligible business customers. The Tasmanian rebate will apply retrospectively and apply to contracts entered into between the 1st of January 2017 and the 30th of June 2018. And this is an example of a policy response by a state government to the media and the political focus and discussion on energy pricing. We also saw AEMC publish version 94 of the National Electricity Rules and version 8 of the NERR, and that's a document that energy retailers would be very familiar with. The version 8 changes include rule changes to the way that energy retailers can collect and use security deposits relating to the termination of market contracts and to transfer without consent. So transfer without consent can occur for a variety of reasons, and up until this point, energy retailers have had an informal process in place that involves transferring that customer back via retrospective transfer. The rule changes formalize this process, but also bring into effect notification requirements. So retailers will need to keep consumers in the loop as they try and resolve an incorrect transfer. Some of the key themes for July and August, of course, focus on the recent increases in market tariffs, and also the fact that we're coming into winter, and winter is obviously a time when consumers see increased energy costs in general. We're seeing the usual concerns about customer consent, explicit informed consent, and also customer hardship. Customer hardship concerns are exacerbated on the back of increased energy costs, and those experiencing customer hardship are obviously a group of consumers that are more likely to be impacted by increasing energy costs. We're also seeing the rise of the interest in embedded networks. So we recently ran a seminar on embedded networks, and there's a lot of different types of businesses that are interested in embedded networks. And one question is how traditional energy sellers will respond to these new types of selling energy. We're also seeing a wave of new entrant retailers. Just today or yesterday, a new retail authorization was approved, and I can tell you that Compliance Quarter is fielding a lot of interest from businesses that are looking to become energy retailers. And I should explain that Compliance Quarter is our sister business that focuses on licenses and compliance related work, working basically predominantly in the energy sector. And alongside that, or separate to that, I should say, we've got Lawquarter, who provides legal services. And the other key theme for July has been the focus on retail profits. And there's a lot of conjecture about, how much money retailers are actually making. A lot of conjecture that is probably way off the mark. So the overall concern is obviously that that retailers are making too much money, and that this is negatively impacting consumers. The background to this is that retail competition has been around for some time. In 2002, Victoria introduced full retail contestability. We had reforms in the 1990s breaking up energy businesses into separate arms, although we still have vertically integrated energy businesses. And we've seen various reforms since that time with the objective of increasing retail competition on the basis that that would place downward pressure on pricing. But now everybody's asking, have all of those reforms delivered on their promise? And as you can see from the graph on the right-hand side of this slide, the obvious answer is no. No, it hasn't decreased pricing pressure by and of itself. Retail prices have increased significantly over the last 10 years, and now regulators and politicians are asking, what needs to be done to put some downward pressure. Of course, retailers will understand that the retail pricing component of a bill is made up of various components. A lot of the price increases we saw in New South Wales over previous years had a lot to do with network costs. And then, of course, we've got the wholesale market. It's hard for politicians and for consumers to understand that there are all of these different components, and ultimately the company that's sending the bill is the one that takes the heat at the end of the day, and that is the energy retailer. So in response to that, we've seen a discussion about the regulatory options that might be available to government to put downward pressure on pricing. And the so-called nuclear option, as first said by, I think it was the ESC Commissioner, in his personal submission on the pricing review, was that we could go back in and re-regulate pricing. Obviously, that's an unlikely option. Something that seems to me to be a pretty obvious target by the ACCC review, which I'll talk about shortly, is the regulation of how retailers talk about discounts on their market offers. At the moment, you can have a retailer that says that it's offering a 30 or 40% discount, but there's no real base price. So to a consumer, that 30% number means absolutely nothing. And it's very easy, I would argue, for consumers to be misled on the basis of stating a particular discount when, in fact, two retailers with one with a higher discount and one with a lower discount, you might have the lower discount having the lower pricing. And so, in terms of standardization of discount reference points, we've seen energy price fact sheets. We've got Energy Made Easy in the NECIA jurisdictions, and Victoria is still clinging on to their own website for some reason. And consumers, they've got some standard information to compare, but they're not switching. And so we've seen a recent meeting between the Prime Minister and some of the larger energy companies, and the Prime Minister stating that households can save between $900 and $1,500 a year on energy prices if they were to switch to the best offer. The problem is, of course, that switching to the best offer is dependent upon that individual consumer actually taking action and providing explicit informed consent in order to switch to a better offer. And not all consumers have been motivated or understand that they're able to take that action and save money. So those retailers at the meeting agreed to another measure, which was to tell customers in plain English when their discount period is coming up to an end, which is obviously on a fixed term contract, telling customers that they're going to move on to a standing rate, and also telling the consumer how much extra that's going to cost them if they don't take any action. The question here is that enough to incentivize a customer to actually have a look and perhaps make some changes? So alongside the Prime Minister's meeting, we've also got the ACCC review. The ACCC has been tasked with investigating pricing. Its inquiry will examine the makeup of the retail bill, the existence of or potential for anti-competitive behaviour by market participants, and the impact of such behaviour on electricity consumers. Their report, a preliminary report, is due to Treasury by the 27th of September, and their final report is due by the 30th of June 2018, and that's quite a long way away. So another area that we're seeing in a general sense a lot of interest in is in exempt energy sellers. So exempt energy sellers, basically a lot of them are in the embedded network space. An embedded network is an area that has been essentially partitioned off from the grid. It will have a gate meter, and it will have various other meters within that embedded network, and the operator of the embedded network only needs to buy the electricity at the gate meter from an authorized retailer, and then can on-sell that to consumers. And the benefit from the embedded network operator's point of view is they can buy that energy at a cheaper rate and then on-sell it to consumers. There's a variety of regulation about how they can do that. There are state-based acts that regulate actual owners or operators of certain embedded networks and stop them from making a profit. There's also the AER licensing and exemption requirements, and similarly in Victoria, although the situation is slightly different there, exempt network operators, if they're selling energy, either need to have a license or operate under an exemption. And if they're operating a network, also need to be concerned to comply with the network licensing requirements. So an interesting submission from the AER, which is the main energy regulator in the NECF jurisdictions, was found in a submission that they made to the AMC review into the regulation of embedded networks, and I've included an extract from that submission in this slide. But basically they said that there's so many new types of selling energy that are coming along, and it's a significant challenge to the regulator and to the effective regulation of these types of entities. And the existing framework for licensing, where you're either a full retail authorized entity or you're an exemption holder, is probably not sufficient. So I wanted to end this presentation with a positive note, and that was found in AEMO's 2017 Electricity Forecasting Insight. And in that they noted that the uptake in solar generation and use of energy efficient appliances will keep grid supplied electricity consumption stable for the next 20 years, despite a projected 30% increase in the population and assumed average economic growth. So all of these changes that present challenges, in particular distributed solar, embedded networks, and energy efficiency, whilst on the one hand you've got them looked at as a political issue. On the other hand, they are actually having a serious and positive impact in terms of keeping electricity consumption stable, and that's forecast to continue for the next 20 years. So that's the end of our presentation for this month. We're going to be running seminars and presentations each month. I've included my contact details there. I should say that in the compliance space, an area that we've been focusing on is the compliance hub that we've developed. And the purpose of the compliance hub is to help electricity retailers demonstrate compliance with the regulation. There is a lot within the compliance hub, and I've designed it on the basis of my own experience having worked within energy companies, and I'm quite confident that it will make the lives of those who are within an energy company, either as legal counsel or as compliance, significantly easier. It makes it a lot easier to submit regulatory reports, to train staff, to track and manage all of the regulation that you need to be across. We have a registry that basically lists all of the obligations that will apply to you and all of the controls that you have in place to comply. And as regulation changes, we'll notify you that you'll need to update your controls. And we also make it very easy for you to search for regulation in an area such as hardship. So, I know from my time that a question will come up from, customer service or whatever area. You literally, in the compliance hub, will type in the word hardship. You don't have to press search, and our system will give you a list of all of the obligations that apply with respect to hardship, so that you can answer that question quite quickly. I'll also include a link to a demonstration we did involving Google Home. So you might be aware of Google Home. It can play music, it can send you reminders, and we're teaching it how to answer questions about energy law. So have a look at our YouTube demonstration and get in contact with me on the details in this slide if you'd like a demonstration, or if you'd like us to send you a Google Home, and we'd be very happy to hear your feedback and to have you using that system and that technology as well. Thanks for your time.